It's my very great pleasure to welcome you here to a lecture by one of my mentors, a colleague, friend. We've taught together, we published together, we did an NEH summer seminar for college teachers together. My goodness. David Little, who is a research fellow at the Berkeley Center of Religion, Peace, and International Affairs at Georgetown University. He retired in 2009 as professor of the practice in religion, ethnicity, and international conflict at Harvard University, and also as an associate at its Weatherhead Center for International Affairs. Before that, David taught at the University of Virginia and Yale Divinity School, and from 1996 to 1998, he was a member of the State Department Committee on Religious Freedom Abroad, which makes him an expert, I think, on religion, human rights, and peace issues. He's the author and co-author of numerous volumes, many of which were published during his tenure as senior scholar in religion, ethics, and human rights at the United States Institute of Peace in Washington, D.C. His most recent book, which I've just had the pleasure of reading and discussing with my class on the foundation of human rights, is a book entitled Essays on Religion and Human Rights, Ground to Stand On, which was published by Cambridge University Press just last year, just last fall. So please welcome David Little, who is going to deliver to us a lecture on human rights, religious freedom, and peace, a subject dear to his heart.
Thank you very much indeed, Barney. It's a great pleasure and privilege to be here. It feels like something of a homecoming, or perhaps better, a family reunion. Since Barney and I have worked together, John Kelsey and I, Eileen Calbian and I, John Corrigan and I were colleagues, briefly at least, at the University of Virginia. And I've come to know a number of the faculty here over the years and feel very much at home here. And I do appreciate being invited back to spend time talking about my recent work. I've already enjoyed meeting some of the students in Barney's class, and I look forward to today and then to tomorrow's colloquium. It's always an honor to be invited to talk about your own work. It's certainly been useful for me, and I do hope it will be so for you. So, human rights, religious freedom, and peace. I have long been interested in this topic, particularly in the relation of religious freedom to peace, but also broadly in the connection between human rights and peace. Certainly it was the solemn intention and expectation of the drafters of the Universal Declaration of Human Rights and all of the subsequent instruments that the promotion and protection of human rights, including the right to religious freedom, would advance the cause of world peace. However, this thesis faces strong opposition, particularly of late. There are a number of scholars who, in the spirit of Michel Foucault, regard human rights as, quote, a discourse of pseudo-emancipation that serves to conceal various entanglements with power. 3 books, 2 just published, apply this conclusion to the subject of religious freedom. The 2 recent books are Beyond Religious Freedom by Elizabeth Shackman Hurd and The Politics of Religious Freedom, edited by Hurd, Saba Mahmood, Peter Danchin, and Winifred Sullivan. Sullivan's older book is entitled The Impossibility of Religious Freedom. This group of 4, Mahmood, Sullivan, Hurd, and Danchin, make up a small group that writes a rather well-known influential blog, I think, called The Imminent Frame. They are dedicated, as they say, to problematizing liberal rights discourse, including human rights discourse. Two other skeptics who approach things from a slightly different angle are Marcy Hamilton, God versus the Gavel, published in '03, and Brian Leiter, Why Tolerate Religion, ? Published in 2013. Other studies, such as The Formation of the Secular by Talal Assad, who incidentally is the mentor of the Imminent Frame group, has been very skeptical, and I'll talk about Assad later on, very skeptical of human rights. And there's another book that has become interesting to me by Oliver Richman called A Post-Liberal Peace, published not too long ago. These all represent challenges. The first group and the second group I've mentioned, challenges to various efforts aimed at promoting peace around the world by institutionalizing human rights and along with democracy and the rule of law, and we'll talk a bit about the interconnection among these things. But these critics that I've just mentioned are really antagonistic to this whole general argument about the web of connections among rule of law, democracy, human rights. They're part, by the way, of a wider anti-human rights campaign that is gathering, I believe, a great deal of momentum these days. I'm thinking of Samuel Moyn's book published in 2010 called The Last Utopia, Human Rights in History, and then a recent book just published last year by Samuel Moyn. He's professor of law at Harvard University. That book is called Christian Human Rights. And then there's another book by a rather well-known international law professor at the University of Chicago, Eric Posner, published just 2 years ago, called Twilight of Human Rights Law, a very sharp critique of the prospects for law and human rights around the world. And I could give you a lot more references, but I hope you get the point that there is a gathering storm against the human rights language and notions. And that seems to me something that we need to take up. After providing some constructive comments about the interconnection of human rights, religious freedom, and peace, I'll get back to dealing with at least 4 of these critics. I'll take up Assad, Oliver Richmond, Winifred Sullivan, and Elizabeth Shackman Hurd. Whatever one may think about the arguments that these people put forward, and I'll try to detail those arguments later on, I do believe, and I disagree with them, as just to anticipate, but nevertheless, I think they raise questions that all of us more pro-human rights people need to respond to. Incidentally, I'll be examining this array of recent anti-human rights literature, as well as some pro-human rights literature, in a long survey review that will appear in the fall in the journal called Law and Religion. So, human rights, religious freedom, and peace. The opening lines of the preamble to the UDHR say this: recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. And the preamble to the UN Declaration on the Elimination of Intolerance and Discrimination based on religion or belief says something very similar. The disregard and infringement of human rights and fundamental freedoms, in particular of the right to freedom of thought, conscience, religion, or whatever belief, have brought directly or indirectly wars and great suffering to humankind. The freedom of religion and belief should contribute to the attainment of the goals of world peace, social justice, and friendship among peoples. These references to peace are not incidental. Human rights in general, and the right to conscience, religion, or belief in particular, were explicitly designed as a set of legally enforceable rights and protections capable of preventing the reappearance of autocratic government and the exercise of arbitrary force associated with Adolf Hitler and his fascist allies that were in large part, not total part certainly, but in large part responsible for the wars and great suffering of the mid-20th century. Speaking of autocratic government and the arbitrary use of force, we should recall that Hitler rose to power on the strength of Article 48, the emergency article of the Weimar Constitution. It permitted the suspension of civil rights with almost no limit, including extensive censorship, widespread searches and seizures, secret and unlimited detentions, the establishment of irregular tribunals to prosecute individuals suspected of threatening national security, in effect, authorizing Hitler to use police power to intimidate and suppress all opposition. We could almost say that the whole human rights corpus, not to mention the corpus of humanitarian law associated with the Geneva Conventions of 1949, was a response to a massive abuse by Hitler and other fascists of an appeal to public emergency. Think, for example, of Article 4 of the International Covenant on Civil and Political Rights, which imposes both stringent requirements of notification and authorization on states claiming a threat of public emergency, and a set of what are called non-derogable rights, namely rights that may not be suspended under any conditions, including public emergency. That set of rights, that set of non-derogable rights, prohibits, even during times of emergency, discrimination, extrajudicial killing, torture, or cruel, inhuman, or degrading treatment or punishment, enslavement, denials of due process, and the freedom of conscience, religion, or belief. Both the conditions and the rights were systematically violated by the Hitler regime prior to and during World War II. In addition, the Hitler experience reinforced the conviction that the drafters, that the cluster of rights spelled out in Articles 19, 20, and 21, that's freedom of opinion or expression, of association, and of participation in government, are universally the first ones dictators will seek to deny and destroy. And one should remember that these derogable rights, namely all the rest of the rights that can be suspended under conditions of emergency, are provided, at least one of their functions is to protect against the violation of the non-derogables. So the more participation, accountability, freedom of speech, association, etc., that you have, the less likely the argument is that people will be subjected to torture, enslavement, arbitrary killing, etc. We ought also to mention in passing the prohibition against atrocity crimes, as they're called. David Sheffer, international lawyer, American, has invented that term. I think it's a very good term indeed. Namely, war crimes, crimes against humanity, genocide, and aggression, all enshrined in the Statute of Rome, which is the charter of the International Criminal Court, violations of which are further examples of arbitrary force that were seared into public memory during the middle of the 20th century. In addition, we should mention the human rights to survival, namely adequate sustenance, health, education, cultural opportunity, embodied in the International Covenant of Economic, Social, and Cultural Rights. Such that disparaging them, disregarding them, deliberately depriving people of them would amount to what I've called arbitrary neglect, which is a very close relative to what I call arbitrary force. These violations of these arbitrary neglect provisions were also very extensive during the Hitler time. I happen to have visited, as some of you may have, Auschwitz and Birkenau, and the systematic way in which denial of food, care, comfort, everything, certainly education, everything that one would come to expect were simply reversed, intentionally, deliberately reversed in the construction of those camps. It is of the greatest importance that Article 18 of the UDHR and the ICCPR, may I say that, ICCPR, International Covenant on the Civil and Political Rights, in both those documents, the right to freedom of conscience, religion, or belief is included, please note, among the non-derogable rights. A key feature of arbitrary force as practiced by the Hitler regime was the relentless imposition by force of a specific set of beliefs on everyone under its control, meaning that persecution of all religious and other expressions of dissent. Such actions were arbitrary because coercion is not a justification for believing the truth or rightness of anything. Since conscience, religion, or belief involve at bottom convictions about truth and rightness, they are subject in traditional language to the law of the spirit, namely persuasive appeals to reason, emotion, and evidence, and not to the law of the sword, not to coercion. That's fundamental. This rationale underlies Article 18, paragraph 2 of the ICCPR, which states that no one shall be subject to coercion which would impair one's freedom to have or to adopt a religion or belief of one's choice. According to the Human Rights Committee, which is authorized by the ICCPR to exposit and declare the authoritative interpretation of the terms of the ICCPR, according to that body, Article 18 protects theistic, non-theistic, and atheistic belief, as well as the right not to profess any religion or belief. Moreover, Article 18 distinguishes between belief and manifestation, such that holding or avowing a conviction may in no way be limited, while manifesting or acting on it may be subject to such limitations as are, quote, prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of everyone. Finally, the committee emphasizes that Article 18 is not limited, please understand this, is not limited to traditional religions or to religions or beliefs with institutional characteristic. It rules out any tendency to discriminate against any religion or belief for any reasons, including the fact that they are newly established or represent religious minorities. There is strong empirical support for the proposition that human rights compliance in general and religious freedom compliance in particular expand the prospects for peace. As to human rights in general, Todd Landman, the author of a careful comparative study, concludes, it appears that greater democracy and interdependence are associated empirically with a reduction of human rights violations and a reduction of interstate conflict. He emphasizes that it is, quote, liberal democracy that is essential for rights protection, where horizontal and vertical accountability are enshrined in constitutionalism and the rule of law, and therefore where rights abuses cannot take place with impunity. In a more recent study by Todd Landman called Human Rights and Democracy, Precarious Triumph of Ideals, published in 2013, Landman continues to stand behind these conclusions, declaring that a strong combination of human rights and democracy significantly reduces lethal repression by elevating political participation and accountability, among other benefits. At the same time, and I would like to emphasize this, he admits that the capacity of democracies right now to uphold human rights and maintain peace, both inside and outside their borders, is sorely tested by the threat of terrorism. And we're all, in this context, fairly aware of that, I think. By emphasizing the interconnection of human rights, democracy, and peace, Landman is here invoking something known in political science circles as the liberal peace. It holds that the orderly and properly sequenced development of robust liberal political and economic institutions, including, quote, a whole panoply of institutions to ensure the rule of law and equal rights, is a critical condition of national and international peace, while illiberal or ethnically exclusivist institutions increase the probability of violence, either of an institutionalized sort, as in autocratic systems, which are able to put down resistance and accountability by force, or in situations outside institutional control, such as insurgencies and civil wars. And may I just add in passing that while I worked at the U.S. Institute of Peace, we studied ethno-religious conflict, and I think our own findings would very much confirm this point. The most important claim of the liberal peace, based on a systematic investigation of thousands of paired or dyadic relationships between countries, is that developed democracies, especially those with a high degree of interstate commerce and membership in international organizations, do not fight each other. It does not say, please note, that developed democracies refrain from fighting non-democracies. The whole history of colonialism, together with the experience of the Cold War, together with our own present experience in the contests between democracies and militant extremism, obviously move against that conclusion. That is to say, against the idea that democracies never go to war. They don't go to war with other democracies, they do go to war with non-democracies. Rather, the more limited claim of the liberal peace, of special interest to us given that the reaction to Hitler's autocratic rule was the inspiration for human rights, is that pairs of democracies are much more peaceful than either pairs of autocracies or mixed democratic autocratic pairs. Nothing comparable to the effect of democratic norms and institutions produces a generalized pattern of dispute avoidance among autocratic states, according to the authors of a well-known study of the liberal peace, a study written a number of years ago by Bruce Russett and John O'Neill. It was called, by the way, Triangulating Peace, Democracy, Interdependence, and International Organizations. The evidence shows that the democratic institutions promotes peace and mutual respect among democratic peoples, enhance human rights, produce higher levels of political participation, and decrease state repression. They serve also to protect mass populations from state indifference during a natural disaster. That was a point made years ago by Amartya Sen in starvation and so forth. If you have a democracy, you prevent the incidence of these natural catastrophes because people are present to argue for various responses. The counter-argument is, of course, that the opposite, namely weak democratic institutions, those that lack inclusiveness and rights and rule of law, foster violence. In regard to intrastate as opposed to interstate violence, democracies do better in general, though it should be noticed that partial democracies experience violent state failures more than either full democracies or autocracies do. That suggests that political transitions are especially perilous, as confirmed by the fact that the vast majority of civil wars in the 20th century occurred neither in democracies nor in autocracies, but in these transitional phases, which is very important and very significant, it seems to me. As to the connection between religious freedom and peace, there is an important study by Brian Grimm and Roger Finca called The Price of Freedom Denied: Religious Persecution and Conflict in the 21st Century. Significantly, the authors indicate that 83% of countries with more than 2 million people have constitutions promising religious freedom. 8% of countries without constitutions have such laws, while only 9% or 13 countries offer no such promises. Nevertheless, the study reveals some disturbing results on the part of governments around the world who do not live up to the constitutional and other legal promises that they make their citizens in regard to religious freedom. The central conclusion of the Fink Brian Grimm study is this: violent religious persecution and conflict rise as government and social restrictions on religion increase. The reverse, they say, is also true. We have demonstrated the pacifying consequences of religious freedom. We have found that when social and government restrictions on religion are reduced, violent religious persecution is also reduced. And by the way, they make the point that the religious freedom provisions are interconnected in important ways, especially with freedom of speech, freedom of assembly, going back to our suggestion that religious freedom is part of a broader bundle of civil and political, not to mention economic rights, all of which are important in the cultivation of peace. That's the general argument of the liberal peace people, which I have now tried to briefly summarize for you. And now we turn to the challenges. There are, as we mentioned, strong objections to this picture of the positive connections of human rights, religious freedom, and peace. Tal al-Assad, distinguished professor of anthropology at the City University of New York, has attracted a devoted following. I already mentioned the Imminent Frame people, but he's got a much wider following than that, calling sharply into question the contribution of human rights and humanitarian law to peace. Though he is not entirely consistent on the matter, he frequently asserts that human rights language does not constitute, as alleged, a transnational system of accountability able to restrain arbitrary force within and among states. On the contrary, it amounts to little more than a set of biased legal instruments whose function is to serve the hegemonic interests of modern nation states, and particularly, by the way, the United States. Assad calls human rights, quote, floating signifiers that can be attached to or detached from various subjects and classes constituted by the market principle and by the most powerful nation states. Rather than foster peace, in other words, the language of international human rights generates, in effect, violent conflict. This is, of course, a very serious charge. The main problem with it is that on inspection, it is rather elusive. Above all, what we need from Assad is a clearer indication of where he stands on the behavior that is now prohibited by human rights and human law standards. When asked once in an interview why there are reports of more human rights violations in the Third World than in Western democracies, Assad responded that, quote, there are quite a lot of dictators in power in Latin America, Africa, and China, as well as the Muslim world, apparently accepting the premise that autocracies violate established human rights standards more than liberal democracies do. And by implication, I take it, that is not a good thing. However, in that same interview, he then returned to form, stating that many of the assumptions underlying rights, and this is their constant point, are biased against practices seen not to be sufficiently Western or to be the result of discriminatory Western policies. It is essential that Assad distinguish between human rights standards he affirms and those he does not, and to identify when the problem is about the standards and when it is about the violation of standards. Until he does that, it is impossible to tell whether the alleged bias involved is in the standards, which he says from time to time, or is in the violation of the standards by the United States, European powers. But that's a very important distinction, it seems to me, which I must suggest is rather imprecisely discussed in the literature written by Tal al-Assad. As mentioned, he is ready to call third world dictators to account for human rights violations, But if he is, then serious questions are raised about his picture of the liberal democratic state as the major source of repression and violence in the world. If, on the other hand, he means to reject most or all existing standards as nothing more than floating signifiers of the hegemonic interests of states like the United States, then he must tell us what he makes of the Nazi record of treatment both of German citizens and captured peoples. Does he object to that record? And if so, what does he recommend as a way of preventing a recurrence of the Nazi state? Are any of the human rights and humanitarian standards of use in helping to prevent modern states from acting like the Nazi state? If so, which ones? If not, what shall replace the standards? And what is the connection of his possibly substitute standards to the question of peace? My point is that until we have answers to these questions, Assad's challenge to the liberal peace remains unproven. Next, we take up the criticisms registered by Oliver Richman in his volume, A Post-Liberal Peace. Richman's special focus is on the peace-building consequences that, he thinks, have followed from efforts to implement the conventional understanding of the liberal peace. He reviews a number of cases of internationally sponsored post-conflict reconstruction, Cambodia, Bosnia-Herzegovina, Kosovo, and Timor-Leste, and concludes that the going version of the liberal peace, which has guided endeavors in those countries, has in large part failed to create the conditions for a durable and just peace. In the name of fostering liberal institutions, constitutionalism, human rights, etc., that are supposed to generate peace internationally and domestically, the effects, rather, have been to strengthen political and economic elites, both inside and outside the government, at the expense of the common people who are living at the everyday level. The special culprit, according to Richmond, are neoliberal economic policies that entrench extensive inequalities in wealth and opportunity, though he mentions other factors as well. I myself do not dispute Oliver Richmond's findings, particularly in the light of our own experience in developed democracies like the United States, about growing social and economic inequality associated with the market economy and the potential, which we ourselves are experiencing, are we not, potential for deep frustration and serious conflict that appear to accompany it. I simply observe that when all is said and done, Richmond does not forsake the liberal peace, but calls instead for it to live up to the full range of its assumptions. He does that by calling for efforts to expand the reach of civil and political rights, to extend to all citizens in these various countries, and not just to the elites. And he goes on to advocate very explicitly the importance of adding, as generally many liberal peace people have not, the rights to survival. That is, those that are in the International Covenant of Economic Social Rights, adequate sustenance, health, education, and extending those as well to all citizens. That is precisely what has not been done in the various countries, and I could speak from some experience in affirming what Oliver Richmond concludes. In Bosnia, I spent a good deal of time there, and I think he's absolutely right about that. It must be admitted that such a policy contradicts some influential interpretations of the market economy and thereby modifies significantly one widespread reading of the liberal peace. At the same time, such a proposal is ultimately consistent with the full range of human rights, civil, political, and economic, social, and cultural, that are inscribed in the existing code. If the liberal peace, then, is taken, as I think it should be, to mean implementing all and not just some human rights, and implementing those rights not just partially, but fully, or as fully as is conceivable, then Richmond is in accord, after all, with what is, I think, a compelling version of the liberal piece. He's simply saying, let the liberal piece take its own, draw the conclusions of its own assumptions. Winifred Sullivan and Elizabeth Shackman Hurd, authors respectively of The Impossibility of Religious Freedom and Beyond Religious Freedom, go further than Richmond and are much closer to Assad's predominant claim against the whole idea of the liberal peace. They believe that human rights language in general and religious freedom language in particular is in reality the language, and these are their words, of oppression, discrimination, and violence. Sullivan doubts that it is possible, as she says, to find any ground for the critique of law outside the legal systems controlled by nations and therefore subject to political manipulation. Human rights guarantees, including religious freedom guarantees, are, quote, undermined by the limitations of language as well as by the, quote, statist monopoly of law common in the modern nations of the West. Elizabeth Hurd sharpens the point. As with human rights language generally, employing the vocabulary of religious freedom authorizes biased understandings of what it means to be religious and what it means for religion to be free. Such an approach risks exacerbating, these are her words, exacerbating the social tensions, forms of discrimination, and intercommunal discourse that human rights language claims to transcend. The underlying argument, and this is a common argument that will be familiar to many of you, I would think, the underlying argument is that all universalistic language, such as we find in the Human Rights Code, is mistaken, and not recognizing that leads to serious abuse and victimization. In regard to religious freedom, for example, there is no one thing called religion that applies all over the world. People in different cultures have very different understandings of the term, and therefore deciding what makes for religious freedom must also vary accordingly. The upshot is that proponents of universal human right to religious freedom wind up imposing coercively and arbitrarily their own ideas and their own biases on those who have very different notions. The undertaking is, as we mentioned, an exercise in oppression and discrimination, and as such is a cause of intercommunal discord and likely increased violence. The particular culprits are national governments who, in the name of advancing freedom, justice, and peace in the world, actually advance their own parochial ideals and interests, something that makes for conflict, not peace. This approach is, as is clear, a direct and systematic assault on the idea of the liberal peace, even the revised view that we discovered in Oliver Richmond. There are several problems, it seems to me, with the Sullivan-Hurd approach. First, it fails to prove that the violations identified by Grimm and Finke do not occur and do not have the violent consequences that they report. Nor do the proponents of this approach prove that the violations they describe amount to anything like the extent of oppression and violence that Grimm and Finke report. Second, the two authors do not succeed in divorcing themselves completely from a human rights approach to religious freedom. For example, Elizabeth Hurd says that there is no such thing as religion as such, and then proceeds to argue that something she calls lived religion, a fluid, loosely organized, non-doctrinaire experience, quote, as practiced by everyday individuals and groups, is regularly subverted around the world by what she calls governed religion, the religion sponsored and imposed by states, and something she calls expert religion, an understanding of religion invented by scholars and lawyers and then imposed upon people who have very different ideas. In effect, Hurd, in my view, has really, as things work out in what she says, simply substituted her own alternative definition of religion. It's now lived religion that is perverted and distorted by government and expert religion. And she proposes an ambitious theory, universal theory, really, of religious freedom that is based on her account of how religion is suppressed by government and by experts. It's a variation on a human rights approach, if you follow me. There's a universalistic appeal, there's government who's offending in various ways and other people, but it's not by any means giving up on the universal approach that is adopted by the human rights position. The emphasis on lived religion is meant to show that the ideas enshrined in the Human Rights Code are biased in favor of a Western and especially American notion of what religion really is. All the talk about conscience and belief in the code bears the stamp of what they call hyper-Protestantism, something that favors a voluntaristic, highly rationalized, tightly organized form of religion that ignores or plays down ritual and ceremony, as well as the kind of flexible, unreflective religious experience that is, according to them, so much a part of the everyday lives of people around the world. However, Sullivan and Hurd, interestingly, do not avoid using human rights concepts after all. At one point, in her book called The Impossibility of Religious Freedom, Winifred Sullivan states, quote, that to be religious is in some sense to be obedient to a rule outside oneself and one's government, whether the rule is understood as established by God or otherwise. It is to do what must be done. This is, it seems to me, a conventional description of freedom of conscience, a rule outside oneself and one's government to which one is ultimately loyal. On her view, a religiously informed conscience, or something like it, stands above and beyond the coercive power of the state, which is exactly the message of Article 18, paragraph 2 of the ICCPR. My guess is, and this is an important point I want to share with you, my guess is that whenever fundamental commitments, whether religious or not, whether in the form of lived religion or not, come into conflict with the state, they quickly crystallize into what we would all recognize as conscientious beliefs. It does not matter whether it is principles or doctrines or rituals or cherished practices lived out in everyday life. Committed persons, in face of persecution, are forced, are they not, to give reasons, to express beliefs, if you will, as to why their commitments are of paramount importance, to defend those commitments, and why those beliefs should be tolerated and not repressed. In other words, there is here the idea of conscience versus state. My point is that whenever any form of religious or quasi-religious expression is at issue, and it is repressed or subverted by a given set of authorities, people are bound to say, wait a minute, we believe this, we have a right to believe this, and so forth. So it doesn't really matter whether it's doctrines or practices. It's the repression problem that raises the conscience versus state question, which Finke and Brian Grimm report on so extensively. It's just another version of that, it seems to me, if you follow me. In fact, Elizabeth Hurd repeatedly calls attention to the way governed religion and expert religion harm groups by disregarding what they believe about themselves. Hurd invokes the example of what she thinks are abuses inflicted on the Alevis in Turkey by defining them officially as a homogeneous religious minority in a way that seriously misrepresents the understanding of Alevism by some other members, classifying Alevism in accord with the categories imposed by governed and expert religion, she says, sanctifies particular understandings of Alevism as orthodox while marginalizing others. Dissenters and those making claims on behalf of Alevism deemed unorthodox or threatening by certain leaders of the Alevi community are disenfranchised. According to Hurd, this is done in part by ignoring the fact that some of the convictions in question are not thought by some members of Alevism to be religious. So you get the point. Imposing this stuff disenfranchises one, discriminates, causes hostility, etc. That's the general proposal being made. But as I look at it, it is hard to see this description, if accurate, as anything other than a case of unwarranted government and expert interference with the conscientious beliefs of some Alevis, of those, by the way, making claims, using her words, making claims on behalf of Alevism. For one thing, the idea of lived religion as something indifferent to belief seems to have been forgotten. There are beliefs being expressed. For another, the critical question on a human rights understanding is not whether the beliefs in question are religious or not, but whether they are conscientious. That is, whether they are of paramount importance and considered worth defending at substantial cost, conscience versus state. If they are, governments and experts are bound to find ways to respect those beliefs subject to specified limitations. That is the meaning of religion or belief. The same applies to another example that Hurd gives. She complains that the logic of religious rights renders politically invisible less established religions, collective ways of life, and modes of being and belonging that do not qualify as religious. She goes on, non-traditional, unprotected religions and non-religions are pushed to the wings. She illustrates the point by referring to the perceived mistreatment of the Quiche people, a Mayan ethnic group living in the northwestern highlands of Guatemala. The Quiche people strongly objected, she says, for religious and cultural reasons to mining operations undertaken on their land by multicultural corporations backed by the state. Their objections were ignored because devotion to the land was not regarded by the authorities, by the state and the experts as legally religious according to the standards that the officials understood. When the case is cast in terms of religion understood as the right to believe or not, violations of the Quiche religio-cultural heritage fall below the threshold of what is to be protected. But such a judgment, as I look at it, seems on its face to be blatantly inconsistent with existing human rights law and jurisprudence. Since religious and cultural reasons are explicitly given in defense of their objections, the issue is not whether an artificial standard of belief is being imposed upon the Quiche people. They are clearly citing beliefs. We have a right to this land. It means this and this and this to us, and the government is transgressing that by its arbitrary activities. They're clearly citing beliefs. It's only whether these beliefs are conscientious. And what is more, non-traditional, unprotected religious and conscientious non-religions are explicitly covered by human rights jurisprudence. Finally, Article 27 of the ICCPR, which, by the way, Guatemala ratified in the year 2000, guarantees that persons belonging to ethnic, religious, or linguistic minorities shall not be denied the right in community with others of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. So, Elizabeth Hurd and Winifred Sullivan do succeed, I think, in providing some egregious examples of the International Religious Freedom Campaign gone wrong by discriminating, in fact, against practitioners of lived religion, the Alevis, the Quiche people, and so on. I do not dissent from that conclusion at all. But what the two authors do not prove, despite their protests to the contrary, is that the vocabulary of religious freedom is incapable of accommodating these troubling examples. The language and categories of religious freedom is elaborated in the commentary of the Human Rights Committee cited earlier are actually quite capacious if carefully read and carefully understood, and are, I believe, able to supply remedies for oversights and mistaken judgments by governments and experts that Sullivan and Hurd report. The fact that the standards are not always scrupulously applied reflects negatively, to be sure, on the officials in question, but not, I think, on the standards themselves. That's my whole point. Let me close, and I will close, I promise you. A little warm here. Let me close by illustrating my point about the capacity of persons charged with upholding religious freedom standards for sensitivity and broad-mindedness, remembering that such persons are typically associated in Hurd's mind with the prejudices of government religion and expert religion. I'm referring here to a memorable dissent by Justice William J. Brennan in a Supreme Court decision called Ling v. Northwest Indian Cemetery Protective Association, a 1988 Supreme Court decision, overruling, by the way, a lower court judgment that the U.S. Forest Service had violated Navajo religion by constructing a road across a mountain that was held sacred by the Navajo people. In supporting Navajo rights that he believed the majority opinion had disregarded, Brennan lost, but he's registering this dissent. He writes as follows: "For Native Americans, religion is not a discrete sphere of activity separate from all others, and any attempt to isolate the religious aspects of Indian life is in reality an exercise which forces Indian concepts into non-Indian categories. In marked contrast to traditional Western religions, the belief systems of Native Americans do not rely on doctrines, creeds, or dogmas. Established universal truths, the mainstay of Western religions, play no part in Indian faith. Ceremonies are communal efforts undertaken for specific purposes in accordance with instructions handed down from generation to generation. Where dogma lies at the heart of Western religions, Native American faith is inextricably bound to the use of land. In my view, Brennan's opinion should surely have prevailed, so I think the Supreme Court made the wrong ruling. But whether he won or not, I'm suggesting his opinion proves that prominent judicial officials charged with upholding religious freedom standards are in fact profoundly capable of appreciating the special perspectives and distinctive interests of indigenous peoples. Well, citing extensive evidence advanced by political scientists who study these matters, I have contended that there is a close connection between human rights, religious freedom, and peace. So far, at least, the sustained and apparently growing drumbeat of opposition against the connection has not, I have argued, succeeded. It is clear that too often human rights and religious freedom standards are not properly applied, as the critics rightly keep asserting. The outcome does cause serious injury and no doubt jeopardizes the prospects for justice and peace in situations where these mistakes occur. But that is more the fault of those charged with the responsibility of interpreting and applying the standards and not of the standards themselves. Thanks very much indeed.